Welcome to New York Arbitration Week, where you are exploring the theme of who is in charge in international arbitration. My name is Tina Cicchetti. I'm an independent arbitrator, and I have been asked to tell you about recent developments in international arbitration in my home jurisdiction of Canada, which, for purposes of international arbitration legislation, is really 14 jurisdictions. Conveniently, all of the international arbitration laws in Canada are based on the UNCITRAL model law on international commercial arbitration. And as you will know, the UNCITRAL model law limits court intervention in international arbitration and gives parties wide latitude to agree to their procedure subject to the requirements of fundamental fairness, that the parties are treated with equality, and that each is given an opportunity to present its case. The Supreme Court of Canada has consistently enforced arbitration agreements in international commercial arbitrations, and courts have respected the legislation limiting their intervention in these disputes. While all Canadian jurisdictions are model law jurisdictions, most laws are still based on the 1986 version of the model law, and work is being done now to update international commercial arbitration legislation in the various jurisdictions to reflect the most recent version of the UNCITRAL model law. Ontario and British Columbia, for example, have now completed this work and have new international commercial arbitration legislation. I wanted to tell you a bit more about a related development in British Columbia and, more specifically, Vancouver. Coincident with British Columbia's update of its International Commercial Arbitration Act, the Vancouver-based arbitration institution, which has been in business since the mid-1980s, has rebranded itself as VANIAC, the Vancouver International Arbitration Center. Now, VANIAC has adopted new international commercial arbitration rules. The rules are state-of-the-art. The overall focus is on the parties and the need to provide for effective and expeditious dispute resolution. The new VANIAC International Arbitration Rules oblige the parties and the tribunal to avoid unnecessary delay and expense. Other features of the rules intended to promote expeditious dispute resolution include the ability for a party to ask for early disposition of one or more issues of fact or law at any point in the proceedings. Second, a default to written direct testimony of witnesses, which is a known tool for reducing hearing time. Third, an express provision addressing virtual hearings, which experience shows can assist in reducing time and expense. And finally, a default time limit of 90 days for a tribunal to render its award after the close of proceedings. In addition, there are specific expedited rules for disputes valued at less than $500,000, which can also be opted into by agreement for larger disputes. The rules also provide for the possibility of interim measures, including before a tribunal has been constituted. This is also consistent with the 2006 updates to the model law. Consistent with the principle of party autonomy, parties may adapt or opt out of these rules if they do not consider them appropriate for their case. I think it's safe to say that in Canada, when parties are clear about their intention to arbitrate their disputes and how, they remain in charge.